Mtazamaji, katika matokeo ya hivi karibuni ni kwamba chama cha Wiper kimemaliza mkutano wake na wale wajumbe wake katika afisi zao kuu hapa jijini Nairobi. Wakati huo huo, Raila Amolo Odinga akishiriki kusikizwa kwa kesi yake Miguna Miguna ya kushiriki kiapo haramu mnamo Jumanne juma jana. Kwanza moja kwa moja na kupeleka katika mahakama kuu Milimani, tufuatilie kesi inavyokwenda ambapo Raila Odinga amehudhuria. Naam, mtazamaji, ni Raila Odinga katika mahakama ya Milimani kufuatilia kesi yake Miguna Miguna. Tutakuwa tunarudi huko katika muda usio mrefu kufuatilia kesi hii inakwenda namna gani baada ya Miguna Miguna kuwasilishwa katika mahakama ya Kajiado. Mtazamaji, idara ya polisi ilikuwa na wakati mgumu kuelezea sababu ya kutomfikisha Miguna Miguna katika mahakama kuu ya Milimani mjini Nairobi na badala yake kumpeleka katika mahakama ya Kajiado. Wakili wa Miguna Miguna walighadhabishwa na hatua ya serikali kukosa kuwasilisha mahakamani mkuu wa polisi na mkuu wa upelelezi nchini kwa kukiuka agizo la mahakama kumwachilia Miguna Miguna Ijumaa alipokamatwa, wala kumfikisha hapo jana kama walivyoshauriwa. Jaji Luka Kimaru alisitisha kikao na anatarajiwa kutoa uamuzi wake baadaye leo.
Can happen to any one of us. It could happen to you. It has happened to Kamino before. It could happen to any one of us. If you conclude the matter in the manner proposed by the DPP, you are giving them a carte blanche to say next time they can deal with us, take us around their fingers are keyring, and do something technical to defeat justice. In fact, before we heard that Mr. Miguna is alive and is in court, we were apprehensive for the worst. It is not impossible to continue imagining that worst to happen, that they get Miguna released on bail in Kajiado, then some accident occurs before Isinya. Miguna must be brought here because they must comply with the order. To the extent that he has not taken plea as of now, they have a duty, and my lord, I propose that you have also a duty to call for him to be brought before you, as you already have anyway, so that these technical procedures they're taking us through do not undermine your authority, the authority of this court, and authority of the law, especially the Constitution.
Na kulikuwa na vurugu nje ya mahakama ya Milimani jijini Nairobi baada ya wafuasi wa Miguna Miguna kuwakabili maafisa wa polisi wakitaka mwanachama huyo wa NRM kuachiliwa. Wafuasi hao walianza kulalamika nje ya mahakama hiyo baada ya kutambua kuwa Miguna Miguna hakuletwa mahakamani jinsi ilivyokuwa imeagizwa na mahakama hiyo Ijumaa iliyopita. Polisi walifaulu kuwatuliza wafuasi hao, wengi wao wakiwa vijana ambao walikuwa wakiwazomea maafisa wa polisi.
You have a wife, you have children. One day they'll suffer more than us. You will die like dogs. And your blood will never be forgiven.
It shall come to pass. It will not stay forever. It won't stay forever.
You also die.
Shughuli za biashara zilitatizika katika mji wa Migori, Awendo na Rongo katika kaunti za Migori wakati vijana waliokuwa na hasira walipofunga barabara kuu ya Isibani ya Kisii kutaka serikali iwaambie aliko Miguna Miguna. Vijana hao waliwasha moto barabarani na kutaka Miguna afunguliwe. Waliozungumza walisema kuwa wenyeji wana wasiwasi mkubwa tangu Miguna akamatwe Ijumaa nyumbani kwake na mahakama kuagiza aachiliwe, lakini serikali ikakiuka amri hiyo ya mahakama.
Sisi tulitoka hapa tukaenda Nairobi tukaapisa baba. Kama anataka asike sisi wote.
Mbona mnachukua ndugu yetu mnamweka ndani wakati anafanya kazi yake? Hatutakubali kitu kama hiyo. Ya kwanza, hiyo tuwezi. Unaona? Ya pili bwana, sisi kama wakazi ya Migori hatutakubali udikteta.
Sisi tumechukua sheria mkono yetu sababu hata serikali wameshindwa kuchukua sheria.
Tukisalia katika habari za Miguna ni kwamba chama cha wanasheria nchini kimeishutumu idara ya polisi kwa kukiuka agizo la idara ya mahakama la kuitaka kumwachilia Miguna Miguna katika mahakama kuu ya Milimani mjini Nairobi. Rais wa chama cha wanasheria nchini Isaac Okero amesema kuwa ni makosa muhimili mmoja wa serikali kupuuza mwingine, kwani huo ni ukiukaji mkubwa wa katiba. Hivyo ameikosoa hatua ya mamlaka ya mawasiliano nchini kuzima mawimbi ya vituo vya KTN News, Citizen na NTV.
Learned this morning of plans to have Mr. Miguna produced before a magistrate at the law courts in Kajiado. And the latest reports are that he has been produced in court and charged. The details of the charge have not reached us yet. This is not in compliance with the order issued by Justice Luka Kimaru. Once again, the state is willfully violating Mr. Miguna's rights under Article 49 by moving him without any notice to his lawyers or his family, and in order to frustrate their access to him, to a court station outside Nairobi, and not where he has been ordered to be produced. It is reprehensible that the state does not react as it should by immediate and unquestioned compliance of lawful court orders. Within the past week, the state has acted in brazen violation of Mr. Miguna's rights by defying one order made of anticipatory bail and 2 orders for his production. It has held him in isolation from his lawyers, friends, and family. It is playing games with the rights of a Kenyan citizen. We are all in great danger. During this time, we have witnessed the state act in flagrant disobedience of court orders for the restitution of broadcast services. And even now, the state has acted only in partial compliance therewith. By doing so, it is violating the Constitution and exhibiting the characteristics of a dictatorship.
Kiapo cha Raila Odinga cha Januari 30 kinazidi kuwapa taabu sio tu vituo vya habari ila pia wanasiasa akiwemo mbunge wa Makadara George Aladwa. Aladwa alikamatwa kwake Ijumaa kabla ya kuandikisha taarifa katika kituo cha polisi na hivi leo pia alifika katika kituo cha polisi cha Nairobi area kutoa taarifa yake.
George Aladwa amejipata mgeni wa mara kwa mara wa polisi leo akifika kituo cha Nairobi area. Kisa na maana,
mimi nilikuwa nimetafutwa kwa kuweza kuhudhuria ile swearing in ya Mheshimiwa Raila Odinga katika Uhuru Park, uwanja wa Uhuru Park tarehe 30 wiki jana Jumanne, na vile kuweza kuwitness hiyo oath ya Mheshimiwa Raila kuweza kuapishwa.
Ijumaa iliyopita Aladwa alitembelewa na polisi kwake nyumbani katika mtaa wa Buruburu akihusishwa na kiapo cha Raila Odinga ambacho sasa kimekuwa chimbuko la masaibu kwa wafuasi wake na vuguvugu la NRM miongoni mwa tuhuma zingine.
Tayari walikuwa shatoa hapo awali wakasema mambo vile iko katika hiyo attack ya nyumba ya Vice President, former Vice President Mheshimiwa Kalonzo Musyoka, na sasa nilishangaa kwamba mimi hata siku hiyo mwenyewe nilikuwa katika county ya Mombasa nikihudhuria ile kamati yangu ya bunge ya lands na siku hapa Nairobi.
Aladwa aliyewahi kuwa meya wa jiji la Nairobi si mgeni wa matukio tata. Kwa mfano, siku ya Mashujaa mwaka 2015 alikabiliwa na tuhuma za usemi wa uchochezi akikamatwa na kushtakiwa, na leo wakili wake akisema madai mengine kasingiziwa.
We are in the process of instituting defamation charges against him so that he can be able to understand that it is wrong to defame an honorable member of parliament who was elected by the people of Makadara. We have proof. They are somewhere there. I have tickets to prove. I'll give you copies of those tickets, boarding passes, that will confirm that Mheshimiwa Aladwa was in Mombasa at the time of that bombing.
Sisi tulialikwa katika Uhuru Park kama viongozi na wabunge wa NASA, na tuliona invitation kama kawaida tunakuwa invited katika mikutano, na hiyo ilikuwa moja zile invitation tulikuwa tumetumiwa, na mimi pia nikiwa mwenyekiti wa chama cha ODM. So mwenye alikuwa anaapishwa si Aladwa ama Kajwang ama Miguna, mwenye alikuwa anaapishwa ni kiongozi wetu Raila Amolo Odinga. Huo ndio anafaa kukamatwa.
Kwa sasa agizo la mahakama limeamrisha vyombo vya usalama kutowakamata Aladwa, TJ Kajwang na viongozi wengine wa NASA, akiwemo gavana wa Mombasa Hassan Ali Joho. Vyombo vya usalama vimeendeleza mikakati ya kuwatia mbaroni wanaodhaniwa kuunga mkono NRM, vyombo vya habari vikijumuishwa, vikidai vuguvugu hilo lilihusika na njama ya kusababisha umwagikaji wa damu wakati wa kiapo chake Raila Odinga. Mark Namaswa, KTN News.
Watanzania wamekuwa wakifuatilia taarifa kuu za Kenya na pia walikuwa waathiriwa wakubwa baada ya serikali kufunga runinga za NTV, KTN News na Citizen ambayo bado haijafunguliwa hadi tunapokwenda hewani. Baadhi yao walitoa maoni wakiwa katika mji mkuu wa Tanzania, Dar es Salaam.
Si kwamba ni Kenya tu, hata hapa Tanzania magazeti kibaya yameweza kufungiwa, lakini anafungiwa kwa makosa gani? Ni pale anapofikia kuyagusa maslahi ya wanasiasa ambao kwa kipindi hicho wameshika hatamu. Kwa hiyo kwanza nipongeze mahakama ya Kenya ambayo imeliona hilo, kwamba imefikia mahala kwamba chombo kimeweza kufungiwa ndani ya wiki kadhaa na kuweza kufunguliwa. Hapa Tanzania naomba waliige hili, kwamba wananchi wanapokea habari kupitia vyombo vya habari. Sasa ifikia muda kwamba pale wanahabari wanapotoa habari kwa wananchi ndio kiboko cha kuachapia, na shauri kwamba hata Tanzania waige mahakama ya Kenya ilichokifanya, kwamba chombo cha habari kimefungiwa ndani ya muda mchache na maamuzi akatoa kuweza kufungulia vyombo vya habari kuweza kufanya kazi yake.
Kikweli taarifa nilipokea vibaya, kwa sababu hauwezi kumwekea mipaka, hauwezi kuwekea mipaka vyombo vya habari, na ni kama unaviendesha vifanye kitu unavyotaka, na muhimili wa habari unajitegemea wenyewe kama wenyewe. Kwa hiyo kitu kilichofanyika kilikuwa sio sahihi. Kwa hiyo kitu ambacho naona kama atakuwa amefungulia itakuwa ni kitu ambacho ni sahihi, na atakuwa na hizo ametambua kitu kosa alilofanya. Vyombo vya habari vinapaswa kuwa huru na wafanye wanachoweza wenyewe, kisingiliwe.
Huwezi kufungia vyombo vitatu vya taarifa habari kwa sababu ya kuapishwa kwa Raila Odinga. Inakuwa ni shida kidogo.
Kiongozi wa Wiper Kalonzo Musyoka leo amelizungumzia suala la uapisho wa Raila Odinga na kushtumu serikali kwa kuzima vituo vitatu maarufu nchini vya habari. Kalonzo amesema hizo ni dalili za udikteta na kwamba NASA haitokubali kamwe serikali kuwanyima Wakenya haki yao ya kidemokrasia.
For muzzling the media and also refusing to honor decisions by the judiciary. For instance, 6 days the media order was issued. And even as we speak, I do not know whether citizens are back on air and in Oro. So this is how serious matters are in our country. And I said I cannot keep quiet. Our chief principal, the Honorable Raila Odinga, was on Hard Talk today. And those who listen to the BBC's Hard Talk will know that that is really, top-notch media. And he was asked a question, you are alone, you stand alone, because even your deputy was not there to swear with you and the core principles. He said no, it was our own strategy. And I want you to know, we have taken a decision that we are going to do what we are doing here. Wiper did not meet today to discuss their coalition partners. They met to discuss the way forward, particularly after the swearing in of the 30th. And the one important question is, when my friend Raila said, Kalonzo will swear later.
Wenyeji wa Suyan na viongozi kutoka maeneo ya Samburu wameitaka serikali kuwakamata wezi wa mifugo ambao waliiba zaidi ya mifugo 2,000 katika uvamizi uliotekelezwa Alhamisi jioni. Wakizungumza katika maziara ya mtaro mjini Maralal, wakiongozwa na waathiriwa ama walikokuwa wakizikwa waathiriwa wawili wa uvamizi huo wa mifugo, viongozi wakijumuisha Gavana Moses Lenonkulal, mwakilishi wa kike Maison Leshomo na mbunge wa Samburu Kaskazini Alois Lentomaaga wameitaka serikali kuhakikisha kuwa mifugo hao wanapatikana na kurejeshwa kwa wenyewe.
Nataka kusisitiza kwamba polisi wafanye kazi yao Samburu. Mpaka sasa hatuna habari. Mpaka sasa hatuna habari ya security team, hatujapata kuongea na commissioner. Polisi ilibidi sisi tuende na nguvu tuhakikishe kwamba vijana wameletwa, wamefanywa postmortem.
Na wazee wanachukua kabisa, watu wanasuia wakutaka hata kuchinja watoto wao, kukata machingo kwa sababu wameona hawana maisha mengine tena.
Wakora wakichukua mali nyayo inaishia, shika mali hiyo watu. Lakini kwenda kunegotiate na wakora, hiyo ni kinyume ya sheria.
Naam, mtazamaji, hebu haraka upesi ni kupeleke katika mahakama ya Milimani ambapo kesi yake Miguna Miguna kwa sasa inaendelea kusikizwa.
Torture and physical abuse, especially taking into consideration the manner in which the applicant was forcefully arrested and his property destroyed. The applicant was apprehensive that his fundamental rights as enshrined in the Constitution would be contravened if the court did not act appropriately to secure the applicant's freedom on anticipatory bail pending his arraignment before court to answer whatever charges that may be brought against him. When the applicant's counsel appeared before this court, that is Justice Wakiaga, under certificate of urgency, the court directed that the applicant be released on anticipatory bail, cash bail of 50,000, pending his appearance before court on the hearing of the application inter partes on 5th February 2018. The court ordered the respondents to be served immediately. As a caveat, the court ordered that should the respondents charge the applicant with a known offense, then the applicant should be presented before court as soon as possible. Immediately upon the order was issued, a cash bail of 50,000 shillings was paid on behalf of the applicant. From the evidence on record, it was evident that the respondents were duly served on 2nd February 2018. However, the applicant was not released from police custody. When the matter was listed before this court on 5th February 2018, counsel for the applicant expressed concern as to the applicant's safety. It was feared that the applicant may have been harmed, taking into consideration the fact that neither his advocates nor family members had seen him since his arrest and detention by the police. From the submission made by learned counsel for the applicant, it was apparent that the applicant was kept incommunicado and was not able to communicate with his advocates. The whereabouts of the applicant was unknown since the police were not willing to disclose where he was being detained. Mr. Mailanyi, for the Director of Public Prosecution, was not able to shed any light as to the whereabouts of the applicant. Indeed, Mr. Mailanyi told the court that he was unable to file any response to the application because the police were either unwilling or had refused to give him any assistance for which he was to make representation to court. This court was concerned that the respondents appeared to be reluctant in complying with the orders that was issued by this court, directing the applicant to be released on anticipatory bail pending further investigations, if at all, or pending his arraignment before court for whatever charges that may be brought against him. This court also took into account the legitimate concerns raised by the applicant's counsel in regard to the safety and welfare of the applicant, noting that no one had seen the applicant since his arrest and detention by the police. It was in light of the above facts that the court directed the second and third respondents to appear personally before this court and show cause why they should not be punished for being in disobedience of the orders of this court. The main concern of this court was that the second and third respondents were required to produce the applicant before this court so that he could be dealt with in accordance with the law. Of course, this court was aware that the second and third respondents, while the second and third respondents to present the applicant before a court of law, then the concerns of the applicant's counsel would have been addressed, in that the applicant would no longer be in the custody of the police, but under the custody of the court, which is mandated by law to deal with the applicant in accordance with the law. The court directed the Director of Public Prosecutions to serve the second and third respondents to be present before the court today, 36 February 2018 at 9 a.m. with their applicant. When the court convened on 6 February 2018, it was informed by Mr. Mutuku, the Deputy Director of Public Prosecution, that the applicant was presented before the Kajiado Chief Magistrate's Court and had been charged with 3 offenses. The court was shown a draft charge sheet. The applicant's counsel, specifically Dr. Kaminwa, was not impressed by this turn of events. He objected to the decision made by the respondents to charge the applicant before the Kajiado Chief Magistrate's Court, an inferior court to this court, yet there was a pending order of this court that the applicant be produced before this court for this court to deal with him in accordance with the law. He further submitted that the respondents must abide by the order issued by this court that required the second and third respondents to be personally present before this court to produce the applicant to be dealt with in accordance with the law. This court, upon hearing the parties, formed the view that it could not substantially deal with the issues raised herein if it was not confirmed that indeed the applicant had been charged at the said court. It adjourned the matter to 12 noon when it was duly informed that indeed the applicant had been presented before the Kajiado Chief Magistrate's Court and had been required to take a plea. That confirmation having been made, the issues for determination by this court are threefold. First, the effect of the orders that were issued by this court requiring the applicant to be released on a dispersory bail on 2nd February 2018 and reiterated by this court on 5th February 2018. As regards this issue, it was submitted on behalf of the applicant that since the respondents had acted in blatant disregard of the orders of this court, then any charge or charges brought against the applicant could not be sustained in view of the contempt of the orders of this court by the second and third respondents. The applicant further argued that this court had the mandate and jurisdiction donated by the Constitution that required it to uphold and protect the human rights, fundamental rights, and freedoms of the applicant. In a sense, the applicant was saying that this court should disregard whatever charges may be brought against him because the applicant's fundamental rights and freedoms had been breached. In response to this submission, it was the respondent's case that since the thrust of the applicant's application was in the nature of habeas corpus, and since the applicant had already been produced before court, then the application had been spent. Whatever remedy the applicant was minded to seek then, he ought to file a constitutional petition to invoke his fundamental rights and freedom, or file a civil suit for damages on account of breach of his constitutionally sanctioned rights and freedoms. This court has carefully evaluated the above arguments. It was clear to this court that the second and third respondents acted in clear breach of the orders of this court issued on 2nd February 2018 that required them to release the applicant from their custody, pending further orders of this court on 5th February 2018. It is not for the respondents to interpret the legality or the veracity of the order issued by this court. It is not open for the respondents to choose whether or not to comply with the orders issued by this court. As public officers, the second and third respondents are required to lead by example by obeying orders issued by the court. The second and third respondents cannot purport to enforce the law by breaking the law. They acted clearly in contempt of the orders of this court by detaining the applicant in breach of the orders issued by this court. This court was concerned that the second and third respondents appeared not to appreciate the seriousness of their action in failing to comply with the orders of this court, hence its decision to summon them to appear before this court. Eventually, the second and third respondent did produce the applicant before a court of competent jurisdiction. It is this court's considered opinion the application achieves this objective of securing the production of the applicant before a court of competent jurisdiction. The applicant's remedy for unlawful detention lies in filing an appropriate suit for damages for breach of his fundamental rights. This court does not have jurisdiction to terminate criminal proceedings brought by institutions mandated by the Constitution to bring criminal charges before courts. This is a position that has judicial approval in the Court of Appeal cases of Dennis Leska-Loshie versus Republic, and it's reported in 2015 volume of Kenya Law Reports, Electronic Kenya Reports, and John Kamau Mbugua versus Republic, reported in the 2010 volume of Electronic Kenya Law Reports. In the High Court Judicial Review Application number 78 of 2015, Republic versus Director of Public Prosecutions, and another ex parte, Chairman Lal, Vrajlal, Kamani, and two others, Justice Odunga held at paragraph 143 of the judgment in respect to a judicial review application dealing with more or less the same issues presented before this court, and I quote, "This court in determining judicial review proceedings ought not to usurp the constitutional and statutory mandate of the respondent and the interested party to investigate and undertake prosecution in exercise of the discretion conferred upon them. It was in recognition of this fact that the House of Lords in the case of Director of Public Prosecution versus Humphreys, reported 1976, Volume 2 of All England Law Reports as page 497, and specifically at page 511, cautioned that, and I quote, a judge must keep out of the arena. He should not have or appear to have responsibility for institution of a prosecution. The functions of prosecutors and of judges must not be blurred. If a judge has power to decline to hear a case because he does not think it should be brought, then it soon may be thought that the cases he allows to proceed are cases brought within his consent or approval. If there is a power to stop a prosecution on indictment in limine, it is my view a power that should be exercised in the most exceptional circumstances," end of quote. As earlier stated in this ruling, the thrust of the applicant's application was to secure his production before a court of competent jurisdiction, and thereafter to secure his freedom by being granted firstly anticipatory bail pending his presentation before court, and secondly, bail. Can you control those persons? Officer, can you go and control those people? Sorry for that. Okay. He secure his freedom by being granted firstly anticipatory bail pending his presentation before court, and secondly, bail pending his trial as provided under Article 49(1)(h) of the Constitution. The applicant shall be at liberty to seek appropriate remedy in a constitutional petition or a suit for damages for breach of his fundamental rights and freedoms during the period that he was detained in breach of the orders of this court. In that regard, the applicant must appear before the court that he has been charged, and if he wishes to challenge the jurisdiction of that court to try him, he is at liberty to file an appropriate application before the appropriate court. The second issue for determination is what remedy the court should offer to the applicant now that he has been produced before a court of competent jurisdiction. This court is of the view that since this court has directed that the applicant be released on anticipatory cash bail of 50,000 shillings, then if he has not yet been charged, he shall so be released pending his appearance before the court that he has been charged. If he has already been charged, then the trial court should consider his application for bail pending trial, subject to the caveat that this cash bail shall not be more than Kenya shillings 50,000. The third issue for determination is whether the third and second respondents' appearance before this court will be necessary now that the applicant has been produced before a court of competent jurisdiction. In view of the sentiments expressed above by this court to the effect that the applicant's rights to sue the second and third respondents for illegal detention has accrued, and in view of the fact that the applicant has already been produced before a court of competent jurisdiction, it may not be appropriate for this court to require appearance of the second and third respondent because it will not serve any useful purpose. For the above reasons, the applicant shall be allowed in terms of the orders issued by this court in their foregoing paragraphs. It is so ordered. So those people shouting, Miguna will be released. So there is no problem. But control your supporters, please. This is a court of law. Is that okay?
No, but that's not the way we should behave.
Yeah. This is not a political rally.
That's the way.
This is a court of law. The prayers you have sought have been granted. So there should not be any cause for alarm.
But on our part, we'd like to say to Your Lordship, thank you very much. We are most grateful to you for your diligence, for your perseverance, and for having stood firm here this morning. My land friend, Mr. Malod, would like to say something. Yes. But my Lord, as a matter of good manners, I always think I received good manners at school. Yes, you are. Many did not. Yes, but I always think that I received good manners. I was taught good manners. Yes. My Lord, with your permission, I would like to acknowledge the presence of our Mzee Raila Odinga, who is here. My Lord, I would also like... You're most welcome. Thank And I would also like to... It's a privilege. Yes, Madam, we are very happy and we remain most grateful to you for taking the trouble to come. We know how busy you are, and for you to come to court, I wish a number of other people in high positions could learn that the courts are to be respected, and you have to come and listen to judges when they are reading their judgments. My Lord, I would also like, if you may permit me, I would like to acknowledge the receipt of my learned lady friend, Mbiu who is also here. I'm privileged to be her classmate. Finally, my Lord, I would like to acknowledge the receipt, the presence of my learned friend, Honorable Senator Tula Kilonzo, who is also here. He has appeared before. Again, my Lord, we thank you. My Lord, there's only one small matter which you may probably try to give me or to give some kind of direction. Strictly speaking, the applicant would be making an appearance before this court as a first lawful appearance. He's being brought here. Yeah, he's coming. But I've already released him on anticipatory basis. It's my ruling. Oh, you have already released him? Of course. But my Lord, you still have jurisdiction. Now, I've already released him. If you heard what I said, yes. If he has not been charged before the court, yes. I've already released him. Yes. Yes. Okay. If he has been charged in court, I've already again released him. So there's no problem. My last friend is, yes. Honorable Tiende. Honorable Tiende Omolo, you had something to say. Yes.
Allow me to address the audience. Please, ladies and gentlemen, allow us to handle this. Please, Please, allow us to handle this. Now, my Lord, I apologize that I had sought to address you earlier. But my Lord, it's because I had wanted to bring to your attention a certain set of facts that arose when my Lord retired to do your ruling. And it is this, my Lord, that while the suspect was presented in Kajiado Court to take a plea, that court, in deference to your jurisdiction, suspended the plea. The plea was not taken and made two orders. One, that the police do produce the accused suspect before the High Court at Nairobi before 3 p.m. today. Two, that once the issue pending are conclusively thrashed out by the High Court, the accused can be brought to this court for plea on 14 February 2017. My Lord, that accords with your order except in one respect. In your order number 2, you proceed to give the accused person, now accused person, bond to the extent of what was deposited. The only thing that is pending is that the accused person has not been brought before you so that he can be released. Our fear, which is legitimate, is that my lord might retire and we might be where we were last Friday. Yes, ma'am.
I know where you come from. You are addressing a constituency, but ourselves, we are addressing the law. I will not get out of this court until he's released. Is that okay?
Thank you.
Yes. So he'll be brought here, I'll release him. And then he'll appear before the other court. And in anticipation of what you have said, I have already issued orders. So where is the problem? Yes. Where is he? Where is he?
What I propose, my lord, is you may John.
No, it's okay, it's okay. It's okay. That's what I want. Yes. What were you saying?
No, I'm corrected my colleague that since he's been seen in court, you direct the order to bring him here.
Okay, I'm informed. My senior, can you control your people? Honorable Rengo, can you go and control your people? Can you control them? Yes. Yes, that's what I'm talking to Honorable Senator Orengo. Please. Just control them. We're in a court of law. Yes, Mr. Mutu. Yes. Senior Counsel Kaminwa, I'm told, I've been informed by my orderly that he's in this building. Okay? Okay? So pursuant to my order, he'll be released. Is that okay? And then he shall appear before the court at Kajiado as ordered by that court. Is that okay? Yes. So I think I'll adjourn at that stage. But if you have any issue, you know my chambers. Yes.
Thank you.
Naam, mtazamaji, ndo funga jamvi ya kutolewa kwa uamuzi huo wa kesi yake Miguna Miguna baada ya kuzuiliwa tangu Jumaa jana kufuatia kushiriki kiapo tatanishi chake Raila Odinga, na kama alivyotoa uamuzi wake Luka Kimaru, jaji wa mahakama kuu ya Milimani, ni ameamuru kwamba Miguna Miguna aachiliwe huru, na iwapo atalazimika kutoa dhamana yoyote isizidi shilingi 50,000 kama alivyoagiza. Na mtazamaji, zaidi ya hayo, mbali na wakili Otiende Amolo kuzungumzia kwamba kwa nini umeruhusu achiliwe, na tunavyojua ni kwamba hakuruhusiwa kule Kajiado kuweza kuitikia mashtaka anayotuhumiwa nayo, na badala yake akasemekana kwamba atarejeshwa katika mahakama ya Kajiado mnamo tarehe 14 Februari. Jaji Luka Kimaru amehakikisha kwamba taarifa alizonazo ni kwamba Miguna Miguna yuko katika jumba la mahakama kuu ya Milimani, na ni kwamba kwa mujibu wa maagizo yake ni kwamba ataachiliwa. agizo jingine alilolitoa katika uamuzi wake ni kwamba mashtaka yote ama makosa yote atakayopatikana nayo basi yatakuwa hayana uzito ama yatafutiliwa mbali, kwa maana waliokuwa wanafaa kumpeleka mahakamani walikiuka maagizo yake, akiwemo Inspekta Mkuu wa Polisi Joseph Boynet pamoja na George Kinote ambaye ni kaimu mkurugenzi wa upelelezi nchini. Kwa mujibu wa kwamba walikiuka agizo la mahakama, basi